Inviting me. Oh, there we go. I'm conscious that this is slightly obscure stuff, but the majority of disclaimer cases arise in the context of insolvency, and given how the economy is currently placed, these are matters with which we'll all probably have to become a bit more familiar over the coming months. Escheat is a function of feudal land ownership, and there is some value in filling in a little bit of that background in order to make the current situation a bit more comprehensible. I'm going to try to do that briefly, and then to give what I hope is going to be a reasonably practical analysis of the main features of the current law. I'm also very conscious that England are playing Germany this afternoon, and therefore I shall do my very best to make sure that I don't overrun so that no one who wants to see it has to miss the kickoff, or more importantly, miss any of my lecture, obviously. When we think of land ownership today, we tend to work on the assumption that the freehold owner has paramount title to his or her land. Indeed, given the pretty much unlimited powers of dealing which are vested in a freeholder, for most purposes, that's a reasonable assumption. But in this corner of the law, it's important to remember that a freeholder is also properly described as a tenant in fee simple. The reason for that is that at heart, all land in this jurisdiction is owned by the Crown. Some of that land remains in the occupation of the Crown, and current convention, as in sections 79 to 81 of the 2002 Land Registration Act, is to refer to that land as demesne land. The remainder is all land which at some point the Crown has granted to another person. Historically, there were multiple forms of tenure, with romantic titles such as Grand Sergeanty, Frankelmoine, and Homage Ancestral. Happily, we needn't concern ourselves here with the details of how each of those functioned or the obligations they imposed on their various tenants to their feudal lords, themselves the recipients of royal largesse. But, which is the crucial point, any sort of tenure, including a fee simple, requires a tenant. If there is no tenant, the land returns to its superior owner, which is what is meant by escheat. An interest without a tenant, escheated back to its lord, and where there was no mean lord, ultimately back to the Crown. And when an interest escheats, it determines. The Crown doesn't obtain the fee simple, but simply holds the land by its own right. As Stanley Burnton QC explained in his very helpful decision in Scmiller Properties and Gesso Properties in 1995, the Crown has an unfettered right to the land. To put it more accurately, the Crown's seigneury is no longer encumbered by the freehold interest. Although many forms of escheat have been abolished, such as escheat for treason, which was removed by the Forfeiture Act in 1870, our much simplified modern system of registered land is still built on those feudal foundations, and consequently escheat does still occur, as is recognised in, for instance, Section 8 of the Crown Estates Act 1961. And there are three sets of circumstances where that happens still. The first is where the Crown has made a grant of the freehold subject to user restrictions and made those user restrictions enforceable by a right of re-entry, which is permitted by Section 3 of the Crown Estates Act, and that right has been exercised. That is extraordinarily rare, and I don't intend to mention it again today. Most commonly, escheat happens where an individual's trustee in bankruptcy or a company's liquidator exercises a statutory power to disclaim an interest in land. And it can also happen on the dissolution of a company at a time when it still holds interest in land. The last point that's worth noting is that, except in extremely rare circumstances where a mean lordship granted before the statute Quia Emptores in 1290 is discoverable, escheat is actually to the Crown, the Duchy of Lancaster, or the Duke of Cornwall, depending on where the land is. For simplicity, I'm going to lump those together and just refer to the Crown for the rest of the lecture, but you do need to bear that in mind. So that's the background history lecture, and it's on disclaimer and dissolution that I'm going to focus for the remainder of our time today. I'm going to start by discussing disclaimer releases. That process is somewhat removed from what I've been discussing above, but the concept of disclaimer is central to the application of escheat in modern times, and it's in the leasehold context that is most often encountered in practice. So it's probably the most sensible starting point, and this way there's a decent chance you'll have got the most useful bit of this lecture under your belts before your attention pretty much build up. There are several provisions in the Insolvency Act 1986 dealing with disclaimer and liquidation, section 178 and following, and also in bankruptcy at section 315 and following. Again, for simplicity, I'm going to focus on disclaimer and liquidation, largely because that's where most of my own experience lies, but also because the essentials of the two processes are mostly the same, though there are some minor differences, particularly in relation to homes. Disclaimer isn't available in other forms of insolvency. Section 178 of the 1986 Act grants a power to a liquidator to disclaim onerous property. Notably, previous statutes required liquidators to seek leave from the court before disclaiming, but the 1986 Act changed that so that in the ordinary case, no such permission is required. Section 1783 then defines the onerous property which can be disclaimed as A, any unprofitable contract, and B, any other property of the company which is unsaleable or not readily saleable, or is such that it may give rise to liability to pay money or perform any other onerous act. Accordingly, where a liquidator considers a company's lease to impose a burden on it, rather than representing an asset which can be positively realised, he's not required to keep it, but can effectively wash his hands of it by the process set out in the statute. Of course, leases don't determine on liquidation or insolvency, and therefore the obligations contained in them, first among them the obligation to pay rent, continue to bind. Indeed, such rents are often payable as an expense of the liquidation. In any event, a lease will almost always be on terms which may give rise to a liability to pay money or perform another onerous act, brimming with service charge provisions, dilapidations, liabilities, and so on as they are. In a case called Rehan's Place in 1993, Evans Loam QC found that a liquidator's exercise of his power to disclaim a lease can only be challenged in circumstances where that decision has been influenced by bad faith or is perverse, so as to justify a challenge under Section 168 of the Act. Essentially then, a lease is almost always onerous property for these purposes if the liquidator should so conclude and decide to disclaim it, and thereby relieve the company from the obligations in the lease which would otherwise bind it. The procedure for disclaimer is relatively straightforward, where the liquidator decides to take that route and merely requires him to prepare and file notice at court. The procedure for that is currently set out in Part 19 of the Insolvency England and Wales Rules 2016. Within 7 business days after the date of the notice, he must also deliver a copy to every person who claims an interest in the disclaimed property, is under any liability in relation to it, which is not discharged by the disclaimer, or if the disclaimer is of an unprofitable contract, is a party to that contract or has an interest under it. By Section 179, the necessary recipients include every person claiming under the company as under lessee or mortgagee. There is no time limit on the exercise of this power by the liquidator. However, Section 1785 entitles a person interested in the relevant property to require the liquidator to declare whether or not he will disclaim. Thereafter, the liquidator has a period of 28 days to do so, or such longer period as the court may in very limited circumstances allow on application, failing which the power is lost. Importantly, where the liquidator chooses not to disclaim, the argument that rents should be recoverable as an expense in the liquidation is made much stronger, because the liquidator has elected to retain the interest for the purposes of the liquidation. If he does disclaim, the landlord can recover the property without the risk of an application for relief from forfeiture. So that's really a very useful mechanism for regaining some control if you're acting for a landlord in these circumstances. Where the liquidator does disclaim, the effect is, in the simplest case, of a single landlord having granted a single tenancy to a now insolvent company to determine the lease and accelerate the landlord's reversion. To that extent, it's a relatively straightforward thing. However, substantial complexity is introduced by Section 1784, which provides a disclaimer under this section, A, operates so as to determine, as from the date of the disclaimer, the rights, interests, and liabilities of the company in or in respect of the property disclaimed, but B, does not, except so far as is necessary for the purpose of releasing the company from any liability, affect the rights or liabilities of any other person. What that means is that even though the lease has determined the statute deems the rights and liabilities of third parties to continue as though it was still on foot. To understand what that means in practical terms requires a certain amount of mental gymnastics, and it's preferable to consider different sorts of third parties separately. The leading authority explaining the effect of these provisions is Hindcastle Limited and Barbara Attenborough Associates, with which you're no doubt familiar. Prior to Hindcastle, the leading authority was Stacey and Hill, a decision from 1901. In that case, Mr. Stacey had granted a lease of a shop to a Mr. Chapman, but was concerned that he might not be able to pay the rent, so he also took a guarantee from Mr. Hill. His concerns were justified when a year later Mr. Chapman was bankrupt and his trustee in bankruptcy disclaimed the lease. Mr. Hill paid the rent, as he was obliged to do, up to the date of the disclaimer, but argued that his liability as a surety had ceased when the disclaimer took effect, along with that of Mr. Chapman, on the basis that he had a right of indemnity against Mr. Chapman, and it would be contrary to the purpose of the disclaimer if that liability was not also released. The Court of Appeal agreed with him, and that decision was regularly followed at first instance for the next 95 years until it was overruled by the House of Lords in Hindcastle. In that case, a lease of commercial premises had been granted in 1983 for a term of 20 years. In 1987, the lease was assigned pursuant to a license to assign, which contained a covenant on the part of the assignee to pay the rent and to observe and perform the covenants in the lease for the remainder of its term. A third-party surety was also party to the license to assign, guaranteeing the performance by the assignee of its obligations thereunder. The lease was then further assigned to a company which went into liquidation in 1992 and whose liquidator disclaimed under Section 178. The landlord claimed arrears of rent from the original tenant, the first assignee, and the first assignee's surety. Making the leading speech, Lord Nichols analysed the effect of disclaimer in the following terms. The simplest case is of a landlord and an insolvent tenant. No third parties are involved. Disclaimer operates to determine all the tenant's obligations under the tenant's covenants and all his rights under the landlord's covenants. In order to determine these rights and obligations, it is necessary in the nature of things that the landlord's obligations and rights, which are the reverse side of the tenant's rights and obligations, must also be determined. If the tenant's liabilities to the landlord are to be extinguished, of necessity, so also must be the landlord's rights against the tenant. The one cannot be achieved without the other. Disclaimer also operates to determine the tenant's interest in the property, namely the lease. Determination of a leasehold estate has the effect of accelerating the reversion expectant upon the determination of that estate. The leasehold estate ceases to exist. Where third parties are involved, though, matters become substantially more complex. Lord Nichols explained it as follows. Disclaimer will inevitably have an adverse impact on others, those with whom the contracts were made and those who have rights and liabilities in respect of the property. The rights and obligations of those other persons are to be affected as little as possible. They're to be affected only to the extent necessary to achieve the primary object, the release of the company from all liability. Those who are prejudiced by the loss of their rights are entitled to prove in the winding up of the company as though they were creditors, and that entitlement to prove is set out in Section 1786. He then said, if the problem is approached in this way, the statute takes effect as a deeming provision, so far as other persons' preserved rights and obligations are concerned. A deeming provision is a commonplace statutory technique. The statute provides that a disclaimer operates to determine the interest of the tenant in the disclaimed property, but not so as to affect the rights or liabilities of any other person. Thus, when the lease is disclaimed, it is determined and the reversion accelerated. But the rights and liabilities of others, such as guarantors and original tenants, are to remain as though the lease had continued and not been determined. In this way, the determination of the lease is not permitted to affect the rights or liabilities of other persons. The statute has so provided. On the face of it, that puts a guarantor or original tenant in a really difficult position. The guarantor can remain liable to pay rent, notwithstanding that the lease has ceased to exist between the landlord and the tenant, and nobody is in occupation of the premises. By way of example, in a case called Cromwell Developments and Godfrey in 1998, the court found that an original tenant remained liable to pay rent under a lease which had been disclaimed some 10 years previously, and that liability had subsisted throughout the entire period. Lord Nichols's speech in Hindcastle did take some account of the risk to a surety that liability will continue, in that he further noted that if the landlord takes possession, the liabilities of other persons to pay the rent and perform the tenant's covenants will come to an end as far as the future is concerned. If the landlord acts in this way, he's no longer merely the involuntary recipient of a disclaimed lease. By his own act in taking possession, he's demonstrated that he regards the lease as ended for all purposes. His conduct is inconsistent with there being continuing liability on others to perform the tenant covenants in the lease. He cannot have possession of the property and at the same time claim rent for the property from others. Re-entry by the landlord then affects something rather like forfeiture, terminating the ongoing liabilities which subsisted after the disclaimer of the lease. Perhaps unsurprisingly, there are several authorities on the question of when a landlord in these circumstances can properly be said to have re-entered, of which the Cromwell case I referred to before is one. Notably, there is authority that a landlord can secure the premises against intruders without being found to have retaken possession. That's Relvot Properties and Dixon in 1972, and that's quite important reassurance. The landlord, though, is under no obligation to take steps to recover possession of the property in order to mitigate his losses, so says Bogan and Chima, a 1998 case. He can also, interestingly, assign the right to enforce the surety's liability together with his superior interest if he hasn't re-entered. That's a case called Scottish Widows and Tripipatcal in 2003. In Shaw and Dolman, the Court of Appeal had to consider the position of an original tenant under a post-1995 Act lease who had provided an ARGA. The agreement provided that the original tenant's liability would continue for the period during which the assignee is bound by the tenant covenants of the lease. The original tenant, unsurprisingly, therefore argued that since disclaimer had terminated the assignee's liability, its own liability had also fallen away. The Court of Appeal rejected that argument on the basis that it was inconsistent with the reasoning in Hindcastle. The original tenant was liable not only while the assignee was bound by the covenants, but also while it was deemed to be so bound. A similar argument was also rejected in RVB Investments Limited and Bibby in 2013, where the wording of the surety's guarantee limited his liability to the guarantee period, defined as ending on the expiry of the lease, or if earlier, the date on which the lessee ceases to be bound by the covenants in this lease. Mr. Justice Behrens found that a reasonable person should not have understood the parties to have meant the surety's covenants came to an end on such a disclaimer, and specific performance of the surety's covenant to take a new lease was ordered. He was also ordered to pay arrears of rent and service charge. Of course, provisions like the one in RVB often expressly require a new lease to be taken in the event of a disclaimer. Such a provision remains enforceable following disclaimer by a liquidator. Indeed, in RIA Company number 00792 of 1992, ex parte Tredegar Enterprises Limited, it was held that such a covenant constituted a contract by the surety to take a lease of the premises, conditional on the tenant entering into liquidation, the lease being disclaimed, and the landlord requiring the surety to take the lease. Once those conditions were satisfied, that became an unconditional binding contract. And in accordance with Walsh and Lonsdale, the surety thus became liable for rent and service charges even without the execution of a formal lease. Like re-entry, entering into a new lease under such a provision will end the twilight existence of the obligations under the disclaimed lease. A surety can also escape those obligations if he can demonstrate that he would have been released even if the lease hadn't been disclaimed, in the usual circumstances, such as where there's an unagreed variation of the lease terms or a failure to serve a Section 17 notice under the 1995 Act. So it's really worth investigating the position of a surety in these circumstances. You might be able to help The position of a subtenant is slightly different because it's not necessary in his case to deem that the determined lease continues at all. Although Hynecastle didn't actually concern any subtenants, Lord Nichols did provide some obiter dicta in relation to their position. He said, in order to free the tenant from liability, it's necessary to extinguish the landlord's rights against the tenant and also the subtenant's rights against the tenant. The tenant's interest in the property is determined, but not so as to affect the interest of the subtenant. Determination of the subtenant's interest in the property is not necessary to free the tenant from liability. Hence, the subtenant's interest continues. No deeming is necessary to produce this result. Here, the deeming relates to the terms on which the subtenant's proprietary interest continues. His interest continues unaffected by the determination of the tenant's interest. Accordingly, the subtenant holds his estate on the same terms and subject to the same rights and obligations as would be applicable if the tenant's interest had continued. If he pays the rent and performs the tenant covenants in the disclaimed lease, the landlord cannot eject him. If he does not, the landlord can distrain upon his goods for the rent reserved by the disclaimed lease or bring forfeiture proceedings. Importantly then, the sublease continues and the subtenant cannot be evicted by the landlord provided that he complies with the terms of the disclaimed lease. Where he fails to comply with those terms, though, the landlord can enforce against him. In Re AE Realizations 1985 Limited, Mr. Justice Weinlot described the position of the subtenant following disclaimer in these terms, referring to a decision made under the Bankruptcy Act 1869, which is the statutory predecessor of the current provisions. He said, the position under the Act of 1869 was simply this. As between the lessor and the bankrupt lessee, the disclaimer operated as a surrender. As between the lessor and the underlessee, the lease was to be treated as still in existence. As the lease was to be treated as still in existence, the underlessee was entitled to remain in possession during the term of the underlease. However, the lessor retained his rights in rem, that is, his rights to distrain for rent due under the lease, and to forfeit for non-payment of rent or for breach of covenant. If the right to forfeit for non-payment of rent became exercisable, then, subject to the statutory power of the court to relieve against forfeiture, the underlease and the underlessee's right to continue in possession fell with it. If, then, the rent payable under the disclaimed lease is greater than the rent reserved by the sublease, as would ordinarily be the case, the subtenant is obliged to pay the higher rent in order to retain his interest, albeit he might be able to submit a claim for the balance in the liquidation. Whether or not complying with the head lease terms is actually feasible will depend on the individual circumstances, particularly, of course, where the subtenant's interest is only in part of the property which has been devised by the disclaimed lease. You can imagine if you've got a party which owns a single unit in a shopping centre, for instance, and the insolvent tenant had a lease of the whole shopping centre, that might not be something which is reasonable to expect. If the landlord does forfeit for a failure to comply with the terms of the disclaimed lease, it remains open to the subtenant to claim relief pursuant to Section 146 of the 1925 Act. Though, of course, in the ordinary case, relief will be granted on terms that he complies with the head lease, which again may not prove to be an acceptable outcome. There's an example of that in a case called Barclays Bank and Prudential Assurance in 1998. A mortgagee is theoretically in a similar position in that its interest will remain, provided it ensures that the obligations under the disclaimed lease are discharged. In practice, that will probably mean that it's entitled to apply for relief from forfeiture. It has been held, though, in the context of a disclaimer of a freehold, that a mortgagee has power to vest the freehold in a third party by exercising its power of sale. And I can see no reason why the same analysis shouldn't apply by analogy. That's a case called Scamilla Properties and Gesso Properties, which I mentioned before, and I shall come back to in rather more detail in the freehold context in a bit. Of course, this strange twilight existence isn't really sustainable long term in most cases, and for that reason, Section 181 of the Insolvency Act 1986 allows any person who claims an interest in the disclaimed property or any person who's under any liability in respect of it, not being a liability discharged by the disclaimer, to make an application to the court for the vesting of the disclaimed property in either A, a person entitled to it or their trustee, or B, a person subject to such a liability or their trustee. Importantly, the wording is such that the person applying for the vesting order need not necessarily ask for the lease to be vested in himself. The court found that expressly in a case called Leon and Attorney General in 2019. That's actually decided under section 1017 of the 2006 Act, but the terms are identical for these purposes. In the same case, Lord Justice Lewison held that for a person to be entitled to the property doesn't need to mean an absolute entitlement. He said, rather, it means that the court will make a vesting order in favour of the person whose interest in the disclaimed property is such as, in the judgment of the court, to entitle the applicant to the property in the circumstances of the case. The Act gives priority to subtenants and mortgagees for obvious reasons in the grant of vesting orders, but by section 1824, where an underlessee or mortgagee declines to accept a vesting order, that party is excluded from all interest in the property, so their underlease and or mortgage simply fall away. If there is no underlessee or mortgagee willing to accept a vesting order, then by section 1823, the court may make such an order in favour of a person who's liable to perform the tenant's covenants in the lease, so that is essentially a surety, and can vest the interest in them, freed from all estates, encumbrances and interests created by the company. That gave rise to an interesting set of facts in the AE Realisations case, where a lease had been granted to a company and its surety covenanted to take a new lease on disclaimer. The company granted an underlease and took a substantial deposit. The tenant company went into liquidation and the liquidator disclaimed. The landlord called on the surety to take a new lease pursuant to its covenant, but the surety sought a vesting order, apparently with the intention that it should acquire the old lease with the benefit of the sublease and the deposit, rather than a wholly new interest with no such benefits. But Mr. Justice Weinlot refused that application. Since the underlessee had elected not to take a vesting order itself, its interest had gone, so the surety couldn't obtain the benefit of that interest. Once the interests of any subtenants and mortgagees have been removed, then unless a surety takes a new lease or obtains a vesting order, the landlord becomes entitled to possession of the property. So he becomes a person entitled to the disclaimed property and will take it free from those other interests which are being destroyed. So the landlord too can't obtain the benefit of underleases. There's a case called Re-ITM Corporation Limited in 1997 dealing with that. Once granted, the vesting order determines the ghost of the disclaimed interest, which is replaced by the new interest held by the applicant without the need for any conveyance. Now, where a vesting order is made in favour of a subtenant or mortgagee, section 1821 provides that the court may not make an order under that section vesting leasehold property in such a party, except on terms making them first subject to the same liabilities and obligations as the company was subject to under the lease at the commencement of the winding up, or, if the court thinks fit, subject to the same liabilities and obligations as that person would be subject to if the lease had been assigned to him at the commencement of the winding up. Of course, the court's preference is ordinarily for the former, which tends to be more onerous because very often there are pre-existing arrears of rent or other liabilities as against the company, which wouldn't pass on an assignment. There's an early example of that called In Re Walker ex parte Mills from 1895. In better news, though, the court is also given power to make an order in respect of part only of the disclaimed lease, which is really helpful for subtenants of part. That provision kicks up its own quite serious issues, though. It contains no mechanism, for instance, for apportioning rents or service charges, and there's no indication of how, for instance, liability for common parts should be dealt with. So those are matters which have to be thrashed out on a case-by-case basis. Whilst disclaimer nearly always arises in the context of leaseholds, it is equally possible, though rarer, for freehold interests to be disclaimed on the basis that they are onerous property within the meaning of section 178. And there are a few examples where that's taken place. In Re Mercer and Moore, way back in 1880, the land was subject to a rent charge, covenants including obligations to erect dwelling houses and build a road, and restrictive covenants, and it was considered that that was sufficiently onerous. More recently, in Hunt and Conwy Borough Council in 2013, there was a burnt out derelict pier, and they were allowed to disclaim that one. And most recently of import is the Scamilla case, which related to 2 blocks of flats let out on long leases, and really is quite an important authority. If you do nothing else after this lecture, I would recommend going to read that case, possibly after the match. It's at this point that I hope, though, that the history lesson at the beginning is going to start proving of some assistance, because where freehold land is disclaimed, as we now know, the land escheats back to the Crown, and that freehold interest determines. That happens automatically and without any further action on the part of the Crown. As before, though, subsidiary interests created out of the freehold, such as leases and mortgages, survive. Where the disclaimed land is registered, the liquidator is obliged to inform the registrar of the disclaimer, and by Section 82 of the 2002 Land Registration Act and Rule 173 of the Land Registration Rules 2003, the registrar can add a notice to HM Land Register to the effect that the freehold estate has been determined. The title remains, partly in order to retain registered subordinate interests, and partly in order to avoid the leaching out of disclaimed freeholds from the process of registration. Exactly how the registrar goes about recording an escheat is described quite helpfully in the Land Registry Practice Guide number 35. But as I say, the most accessible analysis of what's really going on under the hood in these cases is in that Scamilla case, in the enormously helpful decision of Stanley Burnton QC, sitting as a deputy judge of the Chancery Division in 1995. That decision rather charmingly recalls the judge's dismay when even the textbook to which he was referred, published in 1794, directed him to medieval writs of escheat for an explanation of the propositions it was putting forward. The case in fact concerned disclaimer by a liquidator of the registered freehold reversionary interests in 2 blocks of flats let on long leases to residential tenants who were qualifying tenants within Part 1 of the Landlord and Tenant Act 1987, and therefore, on the face of it, entitled to a right of first refusal and any disposal of those freehold interests. Following disclaimer, a mortgagee of those interests purported to sell them to a purchaser in exercise of its power of sale under Section 101 of the Law of Property Act 1925. It is worth reading the whole judgment, as I've said, if you're at all interested in this subject. But the court found that as a matter of common law, outside the 1986 Act, the judge specifically declining to decide whether or not the Crown was bound by Section 178, that disclaimer of the freehold had caused an escheat, so the freehold had determined without any positive act by the Crown. Crucially, as with disclaimer of a leasehold, any mortgage or lease granted out of the freehold nevertheless survived unaffected. Unless the Crown took possession in law, it did not assume the liabilities of the freeholder towards any lessee, nor any liability towards a mortgagee. Perhaps surprisingly, and notwithstanding the determination of the freehold interest by escheat, the sale by the mortgagee in exercise of its statutory power under Section 101 was effective to revive the freehold interest and vest it in the purchaser, because Section 104 entitles the mortgagee to sell the mortgaged interest, and that is binding on the Crown. And although the land was in fact held by the Crown at the time of the mortgagee's purported sale, and the 1987 Act does not bind the Crown, the sale was a disposal within the Act. If the tenants had instead been treated as tenants of the Crown, they would have been deprived of their rights under the 1987 Act, notwithstanding the fact that the Crown didn't seek to become their landlord, didn't at any time exercise or seek to exercise any right or power of the landlord in relation to them, and didn't assume the liabilities of their landlord. The judge said, On Escheat, the freehold doesn't pass to the Crown, but determines. The Crown does not, by virtue of Escheat alone, assume the liabilities of the freeholder to, for example, lessees of the freehold. Following Escheat, there is no privity of contract between lessees and the Crown. The Crown is not a successor in title of the freehold and doesn't derive title under him. And the Crown's seigneury is not the reversionary interest immediately expectant on the term granted by the freeholder or his predecessor in title. Similarly, the Crown doesn't come under any personal obligation to a mortgagee in respect of the mortgage debt. In reaching his conclusions, the judge rejected a submission based on the usual common law principle that where a freehold interest determines, all interests derived out of it also determine, often described charmingly as the principle that where the mother dies, the babies die too, and made clear that he was concerned to ensure that disclaimer of a freehold interest should have the same effect on derivative interests as disclaimer of leaseholds. He also rejected a suggestion that Escheat had been abolished in relation to registered land as a result of a provision in the Land Registration Act 1925, which happily entails that the position is identical as between registered and unregistered land. There are also now a few authorities where parties have successfully claimed vesting orders of freehold land following disclaimer by a liquidator or trustee in bankruptcy. So, for example, there's Hackney, London Borough Council and the Crown Estate Commissioners in 1996, where it was found that a local authority had sufficient interest to apply for a vesting order following a bankruptcy based on local land charges over freehold land which it had acquired as a result of works it had carried out on a derelict listed building following the service of dangerous structure notices. The court made the order free from a mortgage of several times the value of the building in its then condition in the face of a supine attitude on the part of the mortgagee. In Fenland District Council and Shepherd in 2011, again, a local authority holding a local land charge sought a vesting order free from a second mortgage over which it had priority. In that case, though, Mr. Justice Roth refused that relief, but indicated that the appropriate order would be to vest the freehold in the local authority subject to both charges. By so doing, he avoided an argument by a rather less supine mortgagee that a vesting order which extinguished its mortgage would be contrary to its Article 1 right to property. There can be some quite interesting issues in these cases. With the little time I have left, I'm going to talk briefly about the second set of circumstances where escheat still fairly commonly occurs, and that is where a company is dissolved while still holding proprietary interests. In the ordinary case of a company which is dissolved in England and Wales, you need to look to Section 1012 of the Companies Act 2006, which provides: 1. When a company is dissolved, all property and rights whatsoever vested in or held on trust for the company immediately before its dissolution, including leasehold property, but not including property held by the company on trust for another person, are deemed to be bona vacantia, and A, accordingly belong to the Crown or to the Duchy of Lancaster or to the Duke of Cornwall for the time being, as the case may be, and B, vest and may be dealt with in the same manner as other bona vacantia accruing to the Crown, to the Duchy of Lancaster or to the Duke of Cornwall. Subsection 1 has effect subject to the possible restoration of the company to the register under Chapter 3. As bona vacantia, both freeholds and leaseholds held by a dissolved company vest in the Crown and are dealt with by the Treasury solicitor on its behalf. At that point, although the interest is in the hands of the Crown, there is no escheat of the freehold property, which continues in existence, and the Crown is liable to third parties to the same extent as the dissolved company was prior to its dissolution. There's a case called Toff and McDowell in 1995, which explains why that is. By Section 1013 of the Act, however, the Crown is entitled to disclaim any such property in the same way as a liquidator may do, within 3 years of the date on which the fact that that property is vested under Section 1012 comes to its attention. If it does so, the property is deemed not to have vested in the Crown pursuant to Section 1012 at all, and disclaimer operates in exactly the same way as disclaimer by a liquidator under Section 178. That is, the rights, interests and liability of the company terminate, but except insofar as is necessary to release the company from liability, the rights and liabilities of other parties are not affected. In relation to leaseholds, then, the effect is just as described in Hindcastle, as I've explained already. There is a weirdness, though, that this applies to freeholds, because if a freehold is disclaimed by the Crown at this point, it bounces straight back to the Crown, but now under the auspices of the Crown Estate Commissioners rather than the Treasury Solicitor, and the escheat occurs. So, as before, in the case of a leasehold interest, disclaimer doesn't take effect unless and until notice has been served on underleases and mortgagees of the company. That's section 1016. And the court has the same power to grant a vesting order in favour of a person claiming an interest in or under a liability in respect of the disclaimed property, in favour of a person entitled to it or under such a liability, or in each case their trustee, under section 1017. And the same limitations on the terms of that vesting order apply where it relates to a disclaimed leasehold. That's section 1018. The process on dissolution should then ultimately be much the same as in relation to disclaimer by a liquidator. But there is one final interesting wrinkle which has given rise to a few recent authorities. Those provisions of the Companies Act don't apply where a company is dissolved overseas, even where the property which it holds is land in this jurisdiction, which means that the property is not caught by those provisions, and there's no entitlement for an interested party to apply for a vesting order under section 1017. That problem first came to my attention when I was instructed in a case called UBS Global Asset Management UK Limited and the Crown Estate Commissioners in 2011. That case concerned a freehold property in Shropshire, owned by a company registered in the BVI. My client had the benefit of an option to purchase the freehold. In 2009, it sought to exercise the option in accordance with the contractual terms, serving notice on the company's London office and on its solicitors. The letter to the company was returned undelivered, and that sent to the solicitors elicited a response that they no longer acted for the company. My client therefore carried out some inquiries and established that the company had been struck off the register and dissolved in the BVI in 2004. Because the Companies Act didn't apply, the claimant's position was instead governed directly by the feudal law of land tenure with which we started. Accordingly, when the company was dissolved, rather than that freehold becoming bona vacantia in the hands of the Treasury Solicitor, its freehold automatically escheated to the Crown and determined, without any need for an intervening disclaimer. In accordance with the careful analysis in Scamilla, however, even at common law, subordinate interests survive the termination of the freehold, and the Crown takes subject to them. Accordingly, we were able to rely on a rather useful old provision at section 181 of the Law of Property Act 1925, which provides where, by reason of the dissolution of a corporation, either before or after the commencement of this Act, a legal estate in any property has determined, the court may by order create a corresponding estate, vest the same in the person who would have been entitled to the estate which determined had it remained a subsisting estate. That is then a provision which allows the court to reinstate a missing fee simple without recourse to the Crown. In UBS, we argued that once all the conditions precedent to the exercise of the option had been fulfilled, the claimant became entitled to the determined estate within the meaning of that provision, and consequently that the court had power to vest a new freehold interest in it pursuant to that section. The court noted that the provision creates a discretion, but absent any objection from the Crown, was willing to make an order on that basis. There are two further points worth noting from that case. The first is that the Crown sought to suggest in correspondence that the effect of the option was to create a trust. As is discussed in Scamilla, there is authority for the proposition that a freehold held on trust doesn't escheat on dissolution of the freehold company, but instead passes to the Crown as bona vacantia subject to the trust and doesn't determine. That's a case called Re Strathblane Estates Limited in 1948. That case doesn't actually consider the authorities on escheat, presumably because the relevant property was in fact deemed to be bona vacantia by virtue of the Companies Act then in force. But in any event, that case has been widely treated as authority for the proposition that a freehold held on trust will survive passing to the Crown, that Section 181 of the 1925 Act doesn't apply, and of course property held on trust is expressly excluded from the effect of Section 1012 of the 2006 Act, so that wipes out 1017 as a sort of a vesting order. And that therefore the appropriate course in those circumstances is instead to make an application under Section 44 of the Trustee Act 1925, which allows for the appointment of a new trustee where a corporate trustee has been dissolved. Of course, a still conditional option doesn't create a trust in land, and my client hadn't fulfilled the conditions until after the escheat had occurred, so the Crown's analysis was rejected by the court. In cases where there is a trust, though, the practice of the court is to allow applications based on that provision, so it's really worth knowing about it. The second point is that we also ran an alternative case which sadly didn't make it into the law report, and that is the even more obscure provision at Section 3.5 of the Law of Property Act 1925. Section 3.3 provides where by reason of an equitable right of entry taking effect, or for any other reason, a person becomes entitled to require a legal estate to be vested in him, then and in any such case, the estate owner whose estate is affected shall be bound to convey or create such legal estate as the case may require. And Section 3.5 then provides, if the owners refuse or neglect for 1 month after demand to transfer or create any such legal estate, or if by reason of their being out of the United Kingdom or being unable to be found, or by reason of the dissolution of a corporation, or for any other reason, the court is satisfied that the transaction cannot otherwise be effected, or cannot be effected without undue delay or expense, the court may, on the application of any person interested, make a vesting order, transferring or creating a legal interest in the manner provided by this Act. I remain of the view that that's an alternative legitimate route by which the court could have granted relief in the UBS case. As far as I'm aware, however, that power has not been exercised in any reported case on Escheat because the court has tended to carry on using 181 as in UBS. But I take the view generally that there's no harm in including it as a backup provision, as a belt and braces approach in these matters. Finally, in all the cases I've had on these provisions since UBS, notably, the Crown has continued to send essentially the same letter referring to Section 44 of the Trustee Act 1925 and indicating that it has no objection to an order being made pursuant to that provision. Only one, I think, of those cases is actually related to a trust interest, but the court has generally been willing to accept that correspondence as an indication that the Crown is content for a vesting order to be made on a basis, absent any substantive objection. Further, in the face of a cogent case for the making of a vesting order, my experience is that the Crown Estate Commissioners won't raise any substantive objection, provided that no costs order is sought against them. And indeed, for a fee, they will confirm that in writing, though I have found that the letter asking for a fee for them to confirm that in writing is itself sufficient evidence of their position to help matters over the line in an unopposed hearing. Another important authority in recent years is Re 5-Star Properties from 2015. In that case, a dissolved company was restored to the register to enable a freehold owned by it to be sold for the benefit of a bank, which held the legal charge over the property. The bank had provided a loan facility to the company secured by the legal charge. The company defaulted, and following the appointment of receivers, the company was put into administration and ultimately dissolved, still in possession of its freehold interest. Under the 2006 Act, the freehold vested in the Crown as bona vacantia, under Section 1012, and the Crown chose to disclaim. The court noted that Section 1012 only deemed the property to be bona vacantia subject to the possible restoration of the company to the register. Since restoration retrospectively deemed the company to have continued in existence as if it had not been dissolved, the company was deemed always to have been the owner of the property, and on its restoration, its freehold would be retrospectively recreated and revested in it. The disclaimer and subsequent escheat did not amount to a disposition of the property within the meaning of Section 1034. The application succeeded and the bank achieved what it had wanted to, but the judge did point out that first, The mortgagee could simply have exercised its power of sale in any event, as was decided in Scamilla. And second, if there was any concern about the efficacy of that sale, it could have been confirmed by an application for a vesting order by the purchaser under section 1017. In any event, I suppose that proves that there are multiple means to the same end. Finally, though, a note of caution. These provisions aren't a magic bullet, and it is necessary to undertake the analysis carefully of these interests bouncing around and converting. The Crown is entitled to deal with escheated land and often wants to do so by creating and selling on a new freehold itself. And the court does need some persuading that it's appropriate for a person claiming an entirely new freehold to be granted one gratis, even where the Crown doesn't actively oppose the application, and even where doing so would apparently lead to a just result. So earlier this year, the court refused a Section 181 application in a case called Lysium Limited and the Crown Estate Commissioners. In that case, a company registered in Gibraltar owned property, which it had intended to transfer to a second company registered in Jersey during a restructure, but the intended transfer had been overlooked. The Gibraltarian company was dissolved and the freehold escheated. The application was made by the intended transferee. The court found that the Jersey company was not a party which would have been entitled to the property in the rather narrow sense in which that phrase was construed in UBS and in a second decision in relation to another option holder called Quadricolor and Crown Estate Commissioners. The Jersey company had no legal right to the property as at the date of the escheat, so was not entitled to a vesting order. The court would, though, have been willing to make an order in favour of the Gibraltarian transferor, which had at that point been restored to the register. Query whether that was necessary in light of the Five Star case. This has been a rather whistle-stop tour of an esoteric area of the law, which I hope has been useful. But I think kickoff is pretty imminent. So to anyone who's stuck with me to this point, thank you very much. And to everyone else who's got half an eye on the football match, fingers crossed for that. Thank you very much for having me.
Thank you.
Thank you very much. I'll let you go.
Thank you.
Thank you very much.
Thank you, Tamsin. Bye-bye.
Thank you.
Thank you very much.
See you later, Tamsin.
Thank you very much indeed.
Good
Goodbye.
night. Bye-bye.
Bye.
Tamsin, having stuck with you, I wondered if I could pick your brain.
What little there is of it, you're very welcome to try.
Possible instruction, maybe. So I am looking at this morning a very Escheat position where company in Gibraltar owned a freehold and has been struck off for non-filing.
Right.
And the property they own is essentially a classic Kensington townhouse converted into flats. And all of the flat owners would love to get together and buy their freehold, not least because they don't even know if it's insured at the moment and they're slightly worried about it. Yep. The problem we've got is we had an initial line of correspondence with Berger Salmon acting for the Crown, who were essentially saying, fine, we'll consider it, but we need to know if this company would ever be restored. So off we went and got a Gibraltarian opinion that said, yes, any company in Gibraltar that struck off for non-filing has 10 years. At any point in 10 years, it could come back again. So we're all slightly scratching our heads as to the fact we are in limbo. It's one of those really frustrating things that if the company was UK, lots of options, but because it's in Gibraltar, it just leaves this hanging. And I think the only way that I can see this actually coming to a head is dragging the Crown into court and seeing what they say. But their initial correspondence has been A, not really our problem, and B, we would be worried that even if we did take a classic enfranchisement premium off you, this company could miraculously Phoenix-like come back again and come after us.
Yep. I think There are obviously the provisions in section 1034 of what happens where the property is disposed of following restoration, and there must be an equivalent provision in the Gibraltarian law as to how matters would stand if the Crown were to dispose of its interest in the interim, because at the moment it's entitled to do that.
Yeah.
I'm not surprised, though, that the Crown has stuck its fingers in its ears, because my experience in these matters is that it's very, very concerned with the provision, it's section 40 of the Crown Estates Act, I think, which says something along the lines of the Crown isn't liable in tort until it starts taking actions that are...
And they're very keen to not be liable for anything at all.
So they're absolutely, so unless and until they're on the cusp of signing off a contract, they tend to just sort of bury their heads in the sand and avoid doing anything, which is how you end up with all these applications going to court with no substantive response. And they tend to sort of fold fairly quickly in the face of those applications, where you put together a fairly cogent point of view. So my first thought is it might be worth checking out what happens in Gibraltar, but yeah, in the interim, there's no reason I can see why you shouldn't apply for a vesting order. And subject to what happens under Gibraltarian law, if the company is restored, there's no reason you can't have a vesting order if you can prove that you're entitled to the property. That phase of it is going to be slightly less straightforward, because you'd have to...
And what do you think the Crown's position would be in the event the company was restored? I suppose it slightly depends on the advice, but what we're wondering is, if essentially we paid off the Crown, whether they'll be prepared to sit on the money for X period of time. And if the Gibraltarian company doesn't miraculously come back after 10 years, then they can keep it.
They might. I suspect you might be faced with the usual, that's a bit complicated. You know, we're happy to wash our hands of a parcel of land and take some money for it, but we don't want to be involved in ongoing obligations, is generally my experience. So I think probably if I were you, I'd be checking out what happens in Gibraltar on restoration to find out whether, if there's been a disposition in the meantime, it takes precedence, which I would have thought it would. And if you can satisfy the Crown as to that, ordinarily they're quite willing to sell. And in circumstances where you'd have the benefit of the enfranchisement legislation, which the Crown broadly follows, as I say, the entitlement question is slightly tricky because the Crown's obligations under the enfranchisement legislation aren't straightforward.
Yes, I mean, I think we're appealing to their you know,
so
you are holding land for the benefit of people, and at the moment we've got people frustrated because no covenants can be enforced, no repair, no insurance, no nothing. You know, it needs to function because people live there. I think the court will be sympathetic to that, but as I say, they do like all the I's dotted and the T's crossed, and I think the Crown will be sympathetic, and they're always happy to take money from people. So I suspect that if you could set out a proposal that you would pay effectively the statutory price, they'd be quite happy with that. But I think it's about getting some certainty as to what's going to happen if they dispose of it in the interim. I mean, at the moment they own it and they can dispose of it, so it shouldn't be a problem. I would have thought so. Brilliant. Tamsin, thank you very much for today. I suspect I might well be back to you with some assistance in writing some long and shirty letters to the Crown.
That sounds fun. Thank you very much indeed.
Lovely. Thank you.
Thank you. Good afternoon.